I'll upgrade. Now today, not about that. I don't know whether he wanted to.
Very close, Lordship.
Yes, please.
My Lord, I beg to upgrade the part har last in the supply item 33. If this can be upgraded after the part 1 as first hearing item. This is already a part hard, my Lord.
Okay.
Much obliged.
Mr. Lordship, our Lordship, I beg to mention item 23.
Yes.
Yes, Lordship, this contempt relates to minimum scale of pay.
Yes. Yes.
So accordingly, the stake we have constituted a committee, Your Lordship. But because of the imposition of the code of conduct, Your Lordship, the committee cannot sit till date. So Lordship, I pray that 4 weeks' time may be granted.
Okay. Miss. Learning Council, you are for the petitioner.
Yes,
I think fair enough. Learning Council for the respondent submits that a committee was constituted.
Yes, Lordship, this is the
Okay. Yeah, your Miss
Ali Tosu.
Learning Council for the petitioner is present. Then Miss submits that. A committee was constituted to examine the existing legislation.
Yes, Lordship.
And
Supreme Court directive.
direction.
with
Supreme
regard
Court
to pay
directives.
parity, yes.
Directives with regards to pay parity between contingent and regular employees.
Yes.
And to constitutes among other to examine, among others, in the last, and to suggest a suitable policy framework for remuneration of contingency and paid employees. However, due to the imposition of
Model code of conduct.
model code of conduct for the ensuing parliamentary elections, the committee could not sit. Could not sit.
Yes, Your Lordship.
And pray for some more time. The prayer is allowed. List this matter after
4 weeks, Your Lordship.
4 weeks. Okay.
Okay, much obliged. Okay.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 29, hearing item 29. On behalf of Wati Jamir, Lordship, kindly this matter will be listed on 25th April 24, since my senior is in bereavement.
Okay. Miss
Alitosu,
Line Counsel for the petitioner. Sorry. Your name is not there.
no, Your Lordship.
Appearing on behalf of
Wati Jamir.
Mr. Wati Jamir, Line Counsel for the petitioner. Praise for. Who is for the other side?
For the state, Your Lordship.
You wanted this matter to be listed
Yes,
on
Your-
28th. Okay. Praise for listing this matter on 28th.
25th, Your Lordship.
Hmm?
25th.
25th April.
Yes, Your Lordship.
Okay, stop. Miss
Livika, Your Lordship.
Libika, Line Government Advocate, Senior Government Advocate, has agreed to the date proposed by the Line Council for the petitioner. Has agreed, list this matter on 25th for hearing. Okay.
Much obliged.
Mm.
Lordship, I also beg to mention item number 26, Your Lordship.
Yes.
Your Lordship, let the matter come up after 4 weeks. This matter also relates to minimum scale of pay.
Okay.
So Your Lordship, let the matter come up after 4 weeks.
Okay. Mr.
Elikasi Sungdam, my lord.
Okay, Likasi Sanctum, Line Council for the petitioner is present. Miss Libika, Line Council, Senior Government Advocate, prays for listing this matter after 4
weeks.
4 weeks.
No blush.
Your Lordship, I also beg to
The
mention
prayer is allowed. List this matter after 4 weeks. Okay,
hearing item number 28 on behalf of Mao Imchin.
okay,
Your Lordship, let the matter come up after 3 weeks, Your Lordship.
okay. Miss Libika, Line Council for.
On behalf of
So,
Mao Imchin.
Have you informed the petitioner,
Your Lordship, I'm informed to adjourn the matter that
to the petitioner? Okay, similar order, huh? Here you are on behalf of mine.
Mao Imchin.
Okay, Libika. On behalf of Mr. Moa Chen, Line Senior Government Advocate, prays for listing this matter after
3 weeks, Your
3
Lordship.
weeks. The prayer is allowed. This is matter after 3 weeks. Okay.
Blush.
Your Lordship, I also beg to mention item number 12.
12.
Your Lordship, 3 weeks may be granted for filing contract.
Yes, affidavit not yet filed.
Yes, Your Lordship.
You are for the petitioner. Okay. Miss
Ms. Kekresinyo.
Line Counsel for the petitioner is present. Miss Levika, Line Government Advocate, prays for
3
2
weeks,
weeks
Your
more
Lordship.
time to file affidavit.
Affidavit.
The prayer is allowed. List this matter after 3 weeks.
Yes, Your Lordship. Your Lordship, I also beg to mention item 20 on behalf of Mao Imchin. Let the matter come up after 2 weeks for filing contract.
And who is for the petitioner here?
I am for the petitioner, Lordship.
Okay. Okay, Mr. Santiago, Line Counsel for the petitioner is present. Miss Lebika. appearing on behalf of here also.
Moam Chen.
Okay, Moam Chen. Pray for listing this matter after
2 weeks, Your Lordship.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Details come before the fixed body after 2 weeks.
Your Lordship, I also beg to mention item number 4 on behalf of Moam Chen. It seems the pleadings are completed. So let the matter come up for.
Admission hearing after 2 weeks, Lordship.
Okay, heard Mr. Sentianger, Land Counsel for the petitioner. Also Ms. Livika, appearing on behalf of Mr. Moam Chen, Land Senior Government Advocate. Staff. Is prayed for by the Land Counsel for the party. List this matter after 2 weeks for admission hearing.
Duly obliged.
Please, Your Lordship. Lordship, I beg to mention item number 9, Your Lordship. I'm appearing for the state, Your Lordship. Here I'm seeking further instructions. So this matter may be kindly listed after 3 weeks, Your Lordship. Yes, ma'am.
Yes, affidavit not yet filed.
Yes, Your Lordship. 3 weeks time may be granted, Your Lordship.
Miss Hale,
Christian.
is present. Land Counsel for the petitioner is present. Miss Hale, Miss
In the holy, Your Lordship.
Nahale. Your government advocate?
Yes, Your Lordship.
Okay. Praise for how much time?
3 weeks, Your Lordship.
3 weeks
Seeking
time
further instructions.
for obtaining instruction and to file affidavit. The prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged. Your Lordship, I also beg to mention item 6 on behalf of my colleague Tibab Home, Your Lordship. Here he's yet to receive instructions. So kindly grant 3 weeks time.
Yeah, 2 weeks. 2 weeks time. Miss
3 weeks, Your Lordship.
Yes, no.
same, huh? The name of
Lordship.
change.
Interim may be allowed to continue.
There is interim order.
There's interim.
Okay, in the last. The interim order passed earlier shall continue till the next date. Okay.
Much obliged. Your Lordship, I also beg to mention item 13 on behalf of Tibab Home, Your Lordship.
Item
Item 13.
13.
Yes, Your Lordship. He's yet to file counter, so kindly grant 3 weeks time, Your Lordship.
Yes, affidavit in opposition not yet filed.
Yes, my lord.
Yes, yes. Mr.
Elikas Sangam, my lord.
L. Likhasab Santam, Land Counsel for the petitioner is present. And Miss,
In the holy, Your Lordship.
Here also you are appearing on.
On behalf of Tibab Home, Your Lordship.
Appearing on behalf of Tibab,
Tibab.
Land Counsel for the Land. He is,
Government advocate, Your Lordship.
okay, advocate for the respondent. Praise for how much time?
3 weeks, Your
3 weeks
Lordship.
time to obtain instruction and to file affidavit. The prayer is allowed. List this matter after
3 weeks.
3 weeks.
Much obliged, Your Lordship.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 18 and 19. Your Lordship, these two matters is analogous with another writ petition, WPC 38 of 2024, which was listed yesterday before my lord. And this court has granted 3 weeks time to the state respondent to file its counter affidavit.
okay.
So if these two matters can be listed along with WPC 38 of 2024 and listed after 3 weeks, my lord.
Okay. So you are for the respondent,
Yes, Your Lordship.
Land Counsel for petitioner.
Petitioner.
Okay. So no objection
Yes,
can
ma'am.
be listed, okay. Miss
Christian.
Land Counsel for the petitioner is present. Mr. Angame, Land Counsel, Land. Here is this is criminal petition. This is criminal petition.
No, Your Lordship. It's
No,
a
sir.
writ petition.
Hmm?
Writ petition, Your Lordship.
17 is criminal
No,
petition.
no, 18 and 19, my
Oh,
lord.
sorry, 18 and 19, not
Yes,
17.
yes.
Okay. 18 and 19. Okay. Land Government Advocate submits that the similar matter, this matter may be listed along with the similar matter being WPC number 38, 2024 after 3 weeks.
My lord, after three.
Okay. List it accordingly. Okay, the prayer is allowed. List this matter along with the WPC number 38, 2024 after 3 weeks. Okay.
Obligement.
May I please, Your Lordship?
Yes,
I beg to mention item number 7.
7.
I'm appearing for respondent number 5, Lordship. I pray that the matter comes after 3 weeks, Lordship.
Okay.
To enable
Have you
review of-
have you informed the petition?
Lordship,
Lordship. Miss,
Lordship, only. Lordship, there is an interim also.
okay, learned counsel for the petitioner is present. Miss Apida,
Lordship,
learned counsel for, learned government advocate for.
Lordship, for respondent number five,
Of the learned counsel for respondent number five.
Five,
Praise
Lord.
for
3 weeks time to
Listed
file
this
my
matter
affidavit in
after 3 weeks.
opposition.
list this matter after 3 weeks. So,
Oblige Lordship,
para, huh? The interim order passed earlier shall continue till the next date. Okay,
oblige Lordship.
May I please, Your Lordship, I
Yeah.
beg to mention item number 24. Lordship, kindly grant 2 weeks time to file a reply to respondent number 1 to 3.
I am appearing on behalf of respondents 1, 2, and 3, Lordship. I have no objections.
okay,
Lordship, and respondent 9 is, service report on respondent 9 is still awaited.
okay. Miss,
Wickets or no?
learned counsel for the petition, hard miss, learned counsel for the petitioner, huh? Start, huh? Who prays for 3 weeks time to file
2 weeks,
2 weeks,
Lordship.
Your
2 weeks
Lordship.
time to file reply to the affidavit filed by the filed by the respondent
1, 2, and 3.
1, 2, and 3 star. Mr. Setyanger, learned counsel for the respondent number 1, 2, 3 has no objection to the prayer made by the learned counsel for the petitioner star. The learned counsel, the learned counsel for the petitioner further submits that the
Respondent 9.
notice upon the respondent 9 is still awaited. In view of the above, list this matter after 2 weeks. Stop. Interim there.
No.
Okay, 2 weeks. Okay.
Deeply obliged.
May I please, Your Lordship, I beg to mention for item number 11.
11.
Yes, Lordship, we have received affidavit in position filed by respondent 1 to 5. Kindly grant
File
us.
reply.
Yes, to file reply.
Reply
2
not
weeks
yet
time.
filed.
Yes, Lordship.
Okay. Miss,
2 weeks.
you are Miss,
Vikono Kiso.
learned counsel for the petitioner. Prays for and is granted. How much time you said?
2 weeks time.
2 weeks time to
Yes,
file
Lordship.
affidavit in reply to the affidavit filed by the respondent staff. Huh? Miss, her name, huh? You are for respondent.
Lordship,
Okay. Learned counsel for the respondent is present, huh? You have written her name? Okay, yes. Yes,
Okay, much obliged.
May I please, Your Lordship?
yes,
Lordship, I beg to mention item number 17, Lordship.
17. criminal
Lordship, on
petition.
behalf of S. Mary, Lordship. If this matter can come up on 23rd, Lordship, Tuesday.
Hmm?
23rd, Tuesday, Lordship.
23rd. Mrs.
No
Secretary.
objections, Lordship.
Okay. Is prayed for by. You are appearing on behalf of
S. Mary, Lordship.
S. Mary, okay.
Lordship.
Mr. Santiago, learned counsel for the petitioner is present. Staff. Miss, her name, huh? Appearing on behalf of S. Mary. Praise for listing this matter on 23rd
Lordship.
April, to which the learned counsel for the petitioner has no objection. The prayer is allowed. List this matter on 23rd. Okay,
Obliged, Lordship.
23rd April, huh?
May it please, my Lord. Lordship, I beg to mention item 15. Here I am yet to file my affidavit in reply. I may be granted 3 weeks, Lordship.
Santiago, learned counsel for the petitioner. How much time?
3 weeks, Lordship.
Praise for, you have no objection.
We have already filed, yes. No objection.
Praise for, and is granted 3 weeks time to file affidavit in reply to the affidavit file, filed by the respondent staff. You are for?
CGC,
Okay,
Gauhati,
Miss,
Desino Kiso.
you are on behalf of?
Gauhati, CGAC.
Okay. Appear on behalf of Mr. Yangavati, the NFCG, SC. Okay,
Deeply obliged.
My pleasure, Lordship. I beg to
Yes.
mention item number 8. For the petitioners, I may be given 2 weeks time to file my reply.
Yes, you have not yet filed.
Yes.
So who is for the? Okay. Miss
Kate Sukru.
A.
Kate Sukru.
Learned counsel for the petitioner. Prays for how much
2
time
weeks time, Lordship.
and is granted 3
Yes, Lordship.
weeks time to file affidavit in reply to the affidavit filed by
Respondent
the
2 and 3.
respondent 2 and 3. Stop. Miss
And April, Lordship.
Learned counsel for the respondent number 2 and 3 is present and has no objection. Stop. The prayer is allowed. List this matter after 3 weeks.
Bless you.
Okay.
Lordship, I beg to mention hearing item number 30 and 31, Lordship. Lordship, I pray that this matter come up after 2 weeks, Lordship.
30 and
And for the
31.
petitioner, Lordship.
Miss.
And April.
And bro, Learned counsel for the petitioner. You are for respondent. Okay. Praise for listing this matter after
2 weeks, Lordship.
2 weeks. Stop. The prayer is allowed. List this matter after 2 weeks. Miss,
Obliged, Lordship.
her name as a government advocate present. Okay. This 30 and 31, huh?
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 32, supplementary list. Lordship, my senior is not feeling well. So my senior SK Medi is not feeling well, so kindly list this matter on 2nd May.
When?
My senior is not feeling well.
Okay. When do you want?
2nd May.
2nd May. Yes,
Yes.
sir. You're for the respondent.
Yes, madam.
2nd May is okay. 2nd May. She's praying for listing this matter on 2nd May.
What's for house?
Hmm?
What's for house? Fixed table. So let it be immediately. Six.
Is it okay?
Yes.
Miss,
Theatre.
your name is there?
Yes, Your Lordship.
Okay, Learned counsel for the petitioner, submits that the leading counsel for the petitioner, Mr. SK Medi, is not well, hence pray for listing this matter on 6th May, to which Mr. India, long chair, I am Learned counsel for the respondent has no objection. He is prayed for by the Learned counsel for the party. List this matter on 6th May for admission hearing. Okay.
Fix, my lord, fix,
Yes, as a
Fixed.
fixed. 6th May is a fixed.
Okay.
fix already.
Yes.
May I please, Your Lordship? I'd like to mention item number 16. So 3 weeks time to file my affidavit in reply.
You want to file reply?
Yes, Lordship.
You are Mr.
Nangsang Ayer.
Learned counsel for the petitioner. Prays for how much time you are?
3 weeks time.
3 weeks time to file affidavit in reply to the affidavit filed by the respondent number, respondent.
1, 2, and
Respondent is 1, 2, and 3.
3.
Okay, stop. Miss,
Lordship.
okay. Learned government advocate is
Lordship,
present
on behalf of Pichano, Lordship.
on behalf of,
Pichano.
okay. On behalf of the channel
Lordship.
is present. The prayer is allowed. List this matter after 3 weeks.
3 weeks.
Okay.
Lordship,
Hmm.
my name and my colleague's name is not reflected in cost list.
Not reflected.
To be reflected.
Your name is?
Nangsang Ayer.
The name of Mr. Namsang
Nangsang Ayer and my colleagues.
Iyer and
Colleague.
what is his name? What is your colleague's name?
They are not
right name, huh? Is not being reflected in the course, may be reflected in the course title. So no, that course list, huh? Is the learning counsel for the petitioner. Okay. You give your name. Okay,
Obliged.
yes,
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 21, lordship.
item
21, lordship. Kindly grant me 2 weeks time to file my counter, lordship.
2 weeks time for
3 weeks time, lordship,
what?
to file counter, lordship.
Counter.
Option for the petition.
Okay. You are Mr.
And carries.
Learning counsel for the petitioner is present. Stop. Miss
Yes, Chang.
Learning government advocate prays for 3 weeks time to file counter affidavit. The prayer is allowed. List this matter after 3 weeks. Okay.
Obliged, lordship.
May it please your lordship, lordship, I beg to mention item 14. Lordship, we have already filed our affidavit and we'll be serving our copy during the course of the day.
Okay. This otherwise, since you have filed, okay, copy or not yet served.
We're yet to
Okay. Miss
Tesenukiso,
Learning counsel for, you are for?
CJC in Yangnawati.
Okay, appearing on behalf of Mr. Yangavati, Learned CGSC, submitted. And the respondent has filed affidavit, a copy. Copy you have not yet
We'll be
served,
serving during the
Okay,
course of the
a
day.
copy. And praise that a copy, she may be allowed to serve copy of the affidavit to the Learned counsel for the petitioner today itself. Okay. Miss, you are Miss?
Alitosu,
Learning counsel for the petitioner. He is present. He is prayed for by the learning counsel for the parties. List this matter after 2 weeks. Okay. You served today itself, huh?
very much.
May I please, your lordship?
Mm.
Your lordship, I beg to mention item number 10.
Then,
Yes, your lordship, here pleadings are completed, so
Yes.
can you the matter may be listed for
served the
admission
copy?
hearing?
you have already served the copy. You have received the copy.
Yes, we have filed affidavit in reply
Hmm.
and we have served.
You have received the affidavit in reply. Copy of the affidavit in
Lordship,
reply.
yes.
You have received. Okay. Are Miss
Alitosu,
learning counsel for the petitioner and Miss
Yes, Chang.
Hanem, learning counsel for the respondent number. You are also appearing on.
Lordship, I'm respondent number 5.
Okay. C is for respondent number 1 to 4. Miss, you are for respondent number 1 to 4.
Lordship.
Okay. And Mr. Learning counsel.
Mr. Abel Ayemi.
Okay. The learning counsel for the parties submits that the matter is ready for hearing. Sorry, the pleadings are completed and the matter is ready for hearing. Stop. Huh? So list this matter after. List this matter for hearing after.
2 weeks admission for admission hearing. 2
No.
weeks.
Lordship, if this matter can be fixed during the usual course of time.
Okay. List this matter. For admission hearing.
Yes, your lordship.
Okay, in usual course. Huh? Okay.
Much obliged.
Your lordship, may I beg to place item number 25?
Yes.
I'm for respondent number 1 to 5 on behalf of Railway, representing YP Gupta. As the senior counsel is not present today, may the matter be fixed again.
Okay. So you are for the petitioner.
Yes, Lordship.
Mr.
I'm appearing on behalf of my senior Mojame.
Okay. Appear on behalf of Mr. Moazamir, Learned counsel for, Learned senior counsel for the petitioner. Miss,
Ngong, appearing on behalf of YP Gupta.
appearing on behalf of Wapi Gupta, Learned counsel for the respondent number 1 to 5, prays for listing this matter after
2 weeks here.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Much obliged.
May I please, Lordship? Lordship, I
Yes.
beg to mention hearing item number 27 on
Okay.
behalf of Sir P.B. Paul, Your Lordship. Lordship is out of station, Lordship. So I pray that this matter may come up
When?
after 3 weeks, Lordship.
After 3 weeks.
Yes, Lordship.
Okay. Mr. Medovero, appearing on behalf of
PP Paul.
PV4, Line Council for the petitioner, prays for listing this matter after 3 weeks, to which Miss, okay, Line Government Advocate has no objections. The prayer is allowed. List this matter after 3 weeks.
Lordship, there's an interim, Lordship.
Stop, huh?
There's an interim.
The interim order passed earlier shall continue till the next date. Okay.
Obliged, my lord.
For motion item number 1.
May I please, Lordship?
Yes.
My lord, this is the regular second appeal. The matter is arising out of the customary court. The subject matter is land dispute at Setu Jubza under Kohima district. Just before I open the appeal, I'm just giving a rough idea. The dispute is between the two private parties over a plot of land in Setu Jubza under Kohima district. Then the plaintiff, whom I represent today, he filed plaint in customary court, Dobashi court initially. Then Dobashi heard the matter and decided in favor of the defendant. Then we filed, as per the customary law, we filed the first appeal before the Deputy Commissioner Kohima under Rule 31 of the police and in the Administration of Justice and Police in Nagaland 1937. I'll show, my lord.
Yes.
So when the matter was filed before the Deputy Commissioner Kohima, the Deputy Commissioner, instead of hearing the matter, has transferred the matter to his assistant, the Deputy Commissioner called SDO. Now, SDO had passed the order confirming the decisions of the customary court, Dobashi court. So therefore, this is the second appeal that we have filed before the High Court. Since between Deputy Commissioner and High Court, there is no other court. So we have come to High Court under Section 100 of CPC, my lord. Now, Lordship, I'll just take Lordship to the facts, if Lord, or my lord, before that, I'll just
Whether the SDO can decide.
yes, as
Okay.
per the customary law.
Okay.
Yes, he has the power.
Okay.
Yes, and the order passed by SDO is as the order of DC, because DC has referred the matter to him. Because maybe DC was having administrative
Okay.
exigence that time. So therefore, it is
So
as
SDO is not a subordinate to
no,
DC.
no,
Okay.
in that case.
Okay.
The order passed by SDO will be treated,
Treated as the
because he
order.
has exercised the power DC
Okay.
under Rule 31 of the Administration of Justice and Police,
Okay.
Nagaland,
Okay.
1937.
Okay.
Now, my lord, I'll take lordship to the facts, since this is, or should I just come straight to the impugn order?
Let us see the impugn order
Yes,
first.
my lord, page 33. Page 33, my lord. NHB, page 33 of the appeal, second appeal. I just
Yes.
want to show lordship why the SDO has taken up, and lordship has rightly asked the jurisdiction of the SDO. Now, if lordship sees this is 19 February 2024, subject is same. Now, the case was taken up as per the directive of Deputy Commissioner Kohima. So that is how the case was transferred to him. Therefore, SDO's order, SDO has exercised the power of DC under Rule 31, my lord. Now, my lord, I'll just read the order passed by the SDO, page 34, my lord.
Yes.
May I read it?
Yes.
In the court of SDO Civil Setu Jubja, assistant to the Deputy Commissioner Kohima. In regard the Tejao Sekwasa versus Nungumazu Nipu, I am for Tejao Sekwasa, the appellant here. In regard to a dispute that arose for a plot of land situated in Setu Colony, Setu Jubja, Kohima district, Nagaland, land measuring an area of 17.47 acres approximately and bounded guarded by not so and so. The said issue and dispute was brought and addressed before my office in the form of an appeal filed by the plaintiff Sri Tejao Sekose against the respondent Ningu Mezo Nipu. This prevailing matter was earlier taken up and heard before the Dobashi Court, Setsu Jubda, Kohima District, Nagaland, and judgment was pronounced by the Dobashi Court, whereby the following was passed. Quote, hence, if Salyo clan take oath, swearing, and give the land to Nipu Nume clan, the case will be closed. The oath sworn land will be given to Nipu Nume clan. But since Niala clan also belong to Nipu Nume clan, their share will also be there. Further, since Niala clan had built their houses on the land, those areas will not be touched because there are also Nipu Nume clan. But without the consent of Nipu Nume clan, they will not be allowed to sell out their land or houses. This is the judgment of Dobashi. When Dobashi had already confirmed that the land belonged to me, where is the question that I must take the permission from them to sell my land, my house? That is what I was aggrieved initially, Dobashi judgment. Now the remaining, my lord. In the light of the appeal filed before my office, I have perused through the appeal and the various statements and documents put on record and attributed a thorough examination of the appeal. The respondent, Ningumezo Nipu, appeared before the undersigned and has stated that his preceding generation elders had never taken loan from late Niale Sekose, that is my great-grandfather. However, since Tejao Sekose is also original from the Nipu Nume clan, his father, grandfather, etc. was allowed to cultivate in the present plot of land which is in dispute. The right to claim ownership of the land was not given to them. Further, the Nipu Nume clan would not disturb or claim the existing structures which Tejao Sekose had constructed or developed. 1. As accordance with para 4, 5, 6, 7, 8, and 9, with regard to land which has been developed by Sri Tejao Sekose, it's me. A. The late great-grandfather of Appalan had developed a portion of land into wet terrace, paddy fields, and jum cultivation was also practiced. Also, in the year 1970 to 80, the Appalan had constructed 3 houses in the said plot of land in which the respondent had never raised any claim or intervened with the above mentioned activities. B. Also, in the year 1981, late Chutto Kusa required his irrigation canal to pass through the Appalan land and for which the Appalan had allowed for the same. C. That in the year 2008, Sri Ko Nipu.
Okay, these are the fact of the case.
Correct. Now,
So what is the substantial question?
my lord, now you come to page 30. Lordship may come to page 37.
Yes.
Why I am aggrieved is this. Page 37, paragraph 9. 9, 10, 11 is the judgment. May I read, my lord, paragraph
Yes,
9?
please, sir. Yes, please.
In regard to the first question of the Appalan's family has been in occupation of over 100 years, developing and managing the disputed plot of land. It is clear and apparent that the respondent could have objected to the development activities of the Appalan from the past 100 years. However, no such claim or objection were raised or brought before any competent authority. Accordingly, I am inclined that the developed area within the disputed land belongs to the Appalan, since the Appalan has incurred all expenses for any and for all development where necessitated. When the court itself has already confirmed that I have been in possession for 100 years and no one has disturbed my possession, then where is the question of dividing the land then? That is my grievance. Next page, paragraph 10. In regard to the second queries, any claim of the respondent to the disputed plot of land, it is to my determination that since both the parties in dispute do not possess any documentary evidence pertaining to the claims of ancestral land, this is concerned to pass in negotiation and claims most of the general agreements slash deals slash issues slash disputes were executed verbally and hardly any written document or evidences are in existence. Therefore, aside the portions of land developed by the appellant who has incurred all expenses and losses, let the remaining undeveloped portion of land, 2.5 acres approximately, be in the discourse between both parties or any disputed party for any future vocations as per customs and tradition. How this do this? I'm agreed by this, my lord. When the finding of the landed SDO was already held that more than 100 years I'm in possession. I have constructed more than 3-4 houses. Now, how can the trial court held that the undeveloped area should be given a respondent? The dispute is not confined to developed area or undeveloped area. It is inclusive. So therefore, the order is perverse. This is my case, my lord. The finding is unreasonable and illogical, my lord. Because lordship has seen paragraph 9, when the court has already held that I am in possession of the land, both developed as undeveloped, for more than 100 years, and no objection has ever been raised from any quarter. Then where is the question of having determined other issues in this case, my lord?
What this para 10 exactly
Right.
says? What is para 10?
Para 10,
Hmm.
according to the finding of the SDO, since dispute there is no document there's no document to show that a particular person has documentary support over the disputed land. That is false. I have document. I'll show the lordship right now. In 2014, just one instance. Is due to BC position certificate. Page. Judgment. My lord, the finding of the SDO, Assistant Deputy Commissioner, that I don't possess document is false. I'll show the document. Only one piece of document for the time being. I know that. You should be smart.
So where it says that the remaining undeveloped portion of the lane measuring 2.5
Yes.
areas approximately, this should go to the respondent.
That is what the finding is. That's why it is perverse. Lordship, the finding was simply that I don't possess any document. It's false. The finding was wrong. I have annexed all the document. That's why I'm drawing lordship's attention to show just one document today today's just motion, page 80, my lord. The competent authority DC has issued land possession certificate in my favor. Page 80, my lord. May I read, my lord?
Yes.
Page 80. Office of the Government of Nagaland, Office of Deputy Commissioner, Kohima, Nagaland. Dated 16 September 2014. Land possession certificate. This is to certify that late Sri Ketuni Sekose is my father. Kohima is in possession of land measuring 19.32 acres at Setu Jupta. Then I have enclosed the map. I have the original map, my lord, here. How can the office of SGO say that I have not produced any document to show that I possess the land? When this order has not been challenged in any competent court of law by the respondent?
This was presented before the Dabas.
Very much. It was part of the record, my lord. So therefore, that's why I'm saying in the first instance, the finding of the SDO is perverse and not based on facts and documents.
Whether in any way in the order of the SDO,
Yes, my lord.
the existence of this document.
Nothing was
mentioned,
discussed.
Not discussed.
That is the saddest part, my lord. At the time of trial, at the hearing, I'll show all the document. In fact, I have annexed all the document even today. I don't blame the office of SU because they are administrative official.
Okay.
Yeah.
So,
So therefore, today, the only limited purpose is just issue notice on the suit, and then I have unless there is a stay order, then the order passed by the SDO will be implemented. In that case, this civil appeal, second appeal will be infractious. Therefore, I have filed an IA, my lord. After issuing notice and admitting this, my lord. IA.
okay.
This is RSA 01 of 2024, my lord.
Mr. Ajo, Direct Counsel for the appellant. Party is only one.
Only one, my lord.
Okay.
Private party only.
Para. This is an appeal under section
100 CPC.
of the CPC 1908, read with section 31 and 32 of the rules for the administration of justice and police in Nagaland against the judgment and order dated 19/02/2024 passed by the Assistant to Deputy Commissioner Kohima. What is this Setu Juba?
That's a place, that is subdivisional headquarters.
Setu within bracket.
Setu Jubja.
Setu Jubja, bracket close. In appeal,
Political case.
Case number 03/2022. Okay, start. Issue notice. Returnable by 4 weeks. Can call for record also.
Well,
No, call for the record. Start. The appellant shall take steps upon the respondent by a registered post which heading within 5 days from today. Stop. List this matter after 4 weeks.
and my lord, I have filed an IA along with this. IA number 48 of 2024.
Okay. Mr. Azio, land counsel for the applicant. Stop para. This is an application filed under order 41, rule 5, read with section 151 of the code of the civil procedure code 1908, praying for a stay of the operation of the judgment and order dated 19/02/2024, passed by the Assistant to Deputy Commissioner Kohima
Secure Zubza.
Jubza, bracket close, in appeal poll case
Poll
number
case.
3/2022.
My lord, that much.
Stop. Issue notice. Returnable by 4 weeks. The petitioner shall, the applicant shall take steps upon the respondent by a registered post with AD within 5 days from today. Stop. And list this matter after 4 weeks. Stop. The the interim prayer shall be considered on the next returnable date.
My lord, at least interim today,
Stop.
till the next returnable date. Because lordship, I have
The
to.
interim prayer shall be the stay okay, prayer shall be considered on appearance of the parties, staff.
I have to that para two, my lord, that unless
Okay, stop. Para to what?
I have stated that unless there is an interim, the opposite party, they are likely to approach the trial court for implementations of the judgment.
Having regards to the contention made and the prayer, the submission of the land council for the appellant, stop, come in the interim till the operation of the impugned judgment order dated 19/02/2024.
Yes,
Not be acted upon till the next returnable date.
March of like. March of like.
The order dated, not operation.
March of.
For motion, item number 2.
Yes.
May I please your lordship? My lord, this contempt petition has been filed for non-compliance of this honorable court order dated 4/12/2023, whereby this honorable court has directed the state respondents to complete the process of regularizing the service of the petitioner's late husband within a period of 4 months, your lordship. So pursuant to that, notice was also served upon the respondents on 11/12/2023, your lordship. However, till date, the state respondents have not taken any steps in respect to the applicant petitioner, my lord.
Issue notice.
Lordship.
Okay. Miss
R.H. Gibbs.
land counsel for the petitioner. Para. This is an application for initiation of contempt proceedings under section 11 and 12 of the Contempt of Court Act 1971. And read with Gauhati High Court Rules 1977 and Article 215 of the Constitution of India, staff, yes, India, for non-compliance of the order dated 14/12/2023. 12/2023 passed in WPC number 202/2021. Stop. Issue notice. Issue notice returnable by 4 weeks. Stop. The petitioner shall take steps upon the respondent by a registered post with AD within 5 days from today.
Your lordship, in the course of the day.
Okay. During the course of the day. Stop. List this matter after 4 weeks. Okay.
Obliged, my lord.
For motion, item number 3.
May I please, your lordship?
Yes.
My lord, on the last occasion, that is on 6/2/2024, notice was issued by your lordship, and then in the interim, no step shall be taken pursuant to the imperial order dated 19/1/2024. However, an observation was with regard to the interim, that interim shall be considered after hearing the counsels for the opposite parties. Thereafter, on 22nd February 2024, the respondents entered appearance, and again on 14/3/2024, they were represented and then sought time for filing objection. And the interim order was extended from time to time. Ultimately, on 8/4/2024, the appeal was admitted and the LCR was also called for. However, and that order was passed after hearing both the counsels. But then, since no application was filed for suspension of the interim order, imperial order, that is 19/1/2024, this honorable court was the opinion that let there be a proper application, IA, for suspension of the imperial order. So this application has been filed as a mere formality, lordship, because no formal application was filed along with the appeal. And the LCR has already been called by 2 orders and the appeal has been admitted. So lordship may pass an order suspending the imperial order dated 19/1.
So since you are already protected, no
Yes.
notice will be issued here in this IA.
They have already entered appearance, lordship.
Hmm.
And copy has been served to the opposite parties also.
Hmm.
But unfortunately, none of them are present today.
Since you have filed this and this has been listed, police will have to issue notice, I think.
They are appearing, lordship. They have appeared on the last 2 occasions also,
Okay.
3 occasions, lordship.
Mhm.
And on 8/4/2024, when this order was passed, they also heard, lordship. So the objective of this honorable court, which was passed on 6/2/2024, that they should be heard, and they have been heard, lordship. But since no formal application was filed along with the appeal, so order was, liberty was given to file appropriate application to file, and we have filed, lordship. So let there be a formal order in the IA suspending the imperial order dated 19/1/2024, lordship.
You have received the copy?
Lordship.
Okay. Mr. Zami, Line Council for the Line Senior Council, assisted by
I am Kong Kemen.
M. Konkem, Line Council for the applicant. Staff. In decision IA. Also had Mr. Line Council for sole respondent.
Yes.
Okay, the respondent staff. issue notice. Stop. Since, since Mr. His name, would appeared and accepted notice, no formal notice need be issued to the respondent staff.
Lordship,
By which other interim you are protected? It will be.
there are three orders, Lordship. One is 6/2/2024. And there
The
are
first order, where is the first order?
page 48, Lordship,
By which?
annexure P. This is an order passed by your Lordship. Next page, page 50. Last paragraph, the interim shall be considered after hearing both the parties.
Okay. Issue notice after that returnable with 4 weeks, and since you say that.
Lordship says, my learned friend is
Yes,
accepting
as
notice.
the sole respondent is duly represented, so their learned counsel, no formal notice need be issued to the said respondent, staff, Okay. In the meantime. It will be a continuation of the interim order only.
Lordship,
The interim order passed earlier,
6/2/2024.
the pass of 6/2/2024. Shall continue. 6/2/2024, passed in FA 1/2024 shall continue.
Lordship, since the record has also been called for on 2 occasions,
Record is there.
and no, it has not come.
Lordship,
It has received.
I'm appearing on behalf of my senior counsel, and I have an instruction from my senior counsel that this matter should be listed, must listed in some other days for final argument.
Okay.
No, final argument can be fixed at any date, but then Lordship, since the record LCR has already been called for and the appeal has also been admitted, and since there is already an interim order passed by Lordship on 6/2/2024, only a formal order is required to be issued in this application, Lordship, that since no application has been filed, that is why on 8/4/2024, this honorable court has given liberty to
Yes.
the appellant to file
Only
an
that
IA.
since there was no separate application filed for. praying for,
Yes, that is why,
interim order.
Lordship.
Okay.
So let the impound order be suspended since the IA has already been filed. The formal application has been filed.
By the way, what is the impugned order? Just.
Impound order is at page 17. And on the first day, Lordship has made an observation on the relevant portion, that is at paragraph 25, where the learned trial court, page 17, Lordship, but operative portion is very short, that is at page 43, paragraph 25.
Hmm. 43.
Yes. This is the relevant portion. The learned trial court,
Page 43. No.
IA, Lordship. Or Lordship
In
is
IA.
with the main case. Then
Yes.
in the main case, it's at page, I will better to refer to the main case,
Yes.
257, annexure G. And the relevant portion, which I'm referring to paragraph 25, is at page 293. The relevant portion of the judgment. Here, in this paragraph, this is the operative portion of the judgment of the trial court. The district judge has arrived to a conclusion based on two orders. One order is passed by the Deputy Commissioner Mokokchung, and the other order is passed by this Honorable Court pertaining to another plot of land. So, since this area has been acquired by the Britishers, the land belongs to the government. That was the finding arrived by the district judge, Deputy Commissioner Mokokchung and this Honorable Court. In another case pertaining to other land. But the present dispute is a dispute where the shop permit was given and then he was allowed to run the shop. There is no allotment of land. There is no document also about acquisition of the land by any authority. It is an ancestral land of the petitioners, inherited from his grandfather. So, case ought to have been decided on the basis of the evidence, giving a view of how the property was inherited from time to time. But instead of considering that aspect of the matter, the district judge has relied on a different judgments which was pertaining to another plot of land. So the finding itself is frivolous. And in the other two cases, which is pertaining to another land, they have never said anything about the acquisition by the Britishers. So my question is, from which document the learned district judge came to the conclusion that this has been acquired by the Britishers? There has to be some document and evidence. Okay, in the main state. And where is the allotment of land to the plaintiff?
So since we have already received LCR, the matter will be fixed for,
Final hearing.
matter will be listed for, this is in the for admission hearing,
Admitted already, Lordship.
admitted already.
Yes. By order dated 8/4/2024.
Okay. Then it will be listed for hearing.
Yes.
Okay. Okay. Mr. City Jami, Lana Senate Council, assisted by
M. Kong Jamir.
Kong Jami, Lana Council for the petition, appellant, staff. Also had Mr.
Kavisumi.
Your name is also there, isn't it? In the court list? Okay. Lana Council for the sole respondent staff. LCR is called for, has been received, staff. List this matter for hearing. During the course.
At an early date, yes.
Okay.
But Lordship, paper
use
book
course.
will be required to be prepared.
What?
Paper book. Since it is a first appeal.
Where you have received the record? Okay. So evidence they have recorded.
Yes,
So this be decided by district court.
yes.
Oh, then of course paper book will be required. Okay. Oh, it's fine. In the meantime, let the paper book be prepared and supplied to the parties. Okay, the cost have to be prepared, paid by them. Okay.
They will intimate, registry will intimate.
Okay.
Lordship, to avoid further complications, let there be a formal order in the IA suspending
I
the,
will, we have already passed. In IA.
suspending the
Hmm.
impound order.
Already passed order.
Since Lordship is fixing the matter for hearing,
Hmm.
let there be a formal order in the IA suspending the impound order dated
that
19/1/2024.
Hmm. Then you will say, since the matter has, since the connected appeal has already been admitted and the matter has been fixed for hearing, the impugn order dated the
19/1
the operation of the impugn order dated. This was pronounced on
19/1/2024.
19. Yes,
1/2024.
2024.
In civil suit number
And
1 of
suit number
2018.
1, 2018 shall remain suspended, Okay. Much obliged.
For admission, item number 5. Please, Your Lordship.
Yes.
Lordship, I have moved this writ petition against the order of learned district and session judge Dimapur, wherein he has passed an order of auction of the vehicle of petitioner. That is Bajaj Allianz Insurance Company. If Your Honor will, Your Lordship will allow me, I'll apprise this honorable court with the facts of the matter. In this matter, Your Lordship, relates to one Toyota Fortuner vehicle which was stolen from Delhi in December 2020. And the owner of the vehicle, this vehicle was insured by the petitioner insurance company. And this owner of the vehicle was duly compensated by the petitioner insurance company after his loss. Then this vehicle was recovered by Dimapur East Police Station. And the original owner, the registered owner of this vehicle, was given notice about this recovery by the Dimapur police in December 2021. That the registered owner informed about this factum of the recovery of this vehicle to the insurance company in January 2022. Since the registered owner was duly compensated, the rightful owner of this vehicle was now this insurance company. Now, sir, in March 2022, representative of this insurance company visited Dimapur East Police Station and met the IO of this case, and with his permission, the vehicle, and informed him that the insurance company will seek the custody of this vehicle. The IO then files an final report under section 173 in the court of Honorable CJM Dimapur, along with the seizure report of this vehicle. And without any knowledge of the petitioner, on 11th July 2022, the learned district and session judge Dimapur
The final report submitted when?
Submitted. It was submitted in July. Its final report was submitted August. In February 2022.
Okay.
Yeah.
And
Maybe, yes. Maybe in March 2022, because the endorsement of police commissioner is coming on 10th of March 2022.
So final report submitted on March.
In March 2022, before the court of learned CJM Dimapur.
Hmm.
Now, somehow, on 11th July 2022, the Honorable District and Session Judge summoned this file through his staff, and on 15th July 2022, passed this impugned order for confiscation and auction of this vehicle. And he did not issue any notice of this auction to the petitioner.
Now, how this, if the case was pending before the CGM, how this vehicle came?
This is the basic question.
Hmm?
This is the substantial question here.
What was the offense involved?
No office was involved.
No,
Kindly-
what was the offense? In what offense?
This vehicle was found in abandoned condition.
Oh, abandoned condition.
Yes. And this seizure was reported to the Honorable Magistrate, the CJM, the concerned magistrate. And without him passing any order, the Court of District and Session Judge, he assumed this power as the original court and summoned this file through unofficial channel and passed this order.
Now, how the district judge would know that there is a vehicle unless he has been informed?
He was informed by the police. He was approached by the application was filed by the Dimapur police.
Okay.
Yes.
So, saying what?
That I do not know. I don't have any copy of that application.
We have to
Although,
have that
if your lordship would permit me, kindly see the final report of at page number.
The final report was filed before the CGM,
CGM, yes.
not before the district judge.
No,
But then the police has submitted the report before the district judge.
no. Just they say that one application was filed for this this confiscation, and whereas
Okay, police made an application
police
before the district judge.
made an application.
Okay, then
Then he called the file from the establishment of CJM to himself, and this order was passed within 3 days.
the application was made before him.
The final report was made before the CJM, and one application was filed before the district judge. And without passing any order by the CJM, he passed this order of confiscation as an original court, whereas only the magistrate had the power to pass this. And this was their prayer in the final.
That is true. Why this police has made this complaint?
That is the main question, because this was a very well-maintained, lucrative and new vehicle. If your lordship will see the photographs of the vehicle, if I may show, may kindly see page number 42 of this, my petition.
Page 42.
Yes, sir. I have placed,
That is photograph.
these are the photographs.
Let us see, where is the application made by the police?
We do not have,
Before
we
the-
do not have that, any copy. It was not there on the file also. It was not there on the judicial file also, this application, neither the order of the Honorable District Judge was there on the
Let
file.
us see the order passed by the district judge then.
Please, sir, please.
District judge or session judge?
District and Session Judge,
Session judge. okay.
yes. Principal District and Session Judge,
Okay, let us
Yes.
see. Where is the impugned order?
page number 67 of this petition.
Okay. Yes, let us read.
Yes, sir. This supplementary from the para number 2, I am reading, briefly stated on 3rd March 20.
Just a minute, this supplementary case number so and so is drawn up on receipt of an application from the,
Office in charge.
let us read all.
Yes. The supplementary case number 1 of 2022 is drawn upon on the receipt of an application from the officer in charge of East Police Station, Dimapur, for confiscation and disposal of the seized and
Okay.
claimed vehicle. A Toyota Fortuner bearing registration number so and so with engine number and chassis number so and so. Briefly stated on 3rd March 2021 at about 13:15 hours, the duty party of anti-vehicle theft squad under Commissioner of Police Dimapur spotted a suspected vehicle Toyota Fortuner with registration number so and so parked at City Tower area, Dimapur. Upon verification, the vehicle bore the engine number so and chassis number so and so. The said vehicle was brought to the East Police Station. The details of the vehicle were sent to the Toyota showroom, Dimapur, for ascertaining that particulars, and a WT message was transmitted to all the police stations across India for causing inquiry. The details of the vehicle bearing registration number so and so was received from RTO, whereby the owner was contacted but stated that his vehicle is intact with him. Thus, it was ascertained that the registration number of the vehicle was fake. Thereafter, a vehicle mechanic was engaged and the original engine number, chassis number.
Just a minute, his vehicle is intact with him.
Yes,
Means,
means that the vehicle, this registration number was fake. when this owner of this registration numbers were contacted by RTO, he got the
What-
message that his original vehicle is intact with him. So therefore, this
Original
registration-
vehicle was intact with him.
yes,
That
this
means-
vehicle was driven with fake registration number plate.
Okay,
So
okay.
the fake registration number plate vehicle was intact with the,
Registration number of the vehicle was, okay, the registered number of the seized vehicle was fake.
yes, sir.
So this, the vehicle number, original vehicle
Yes.
of this seized,
The original number of this seized vehicle was HR6DV171. HR26, this is not wrong, rightly mentioned, HR26DV171.
no, this,
The original number was with this, but it was driven with fake registration plate, yeah, lordship.
okay,
Okay, sir. May I read further?
thereafter,
Hi, thus, thereafter vehicle mechanic was engaged and the original engine number and chassis number was found out to be engine number so and so, chassis number so and so, and with the help of NCRB, Office of Commissioner of Police Dimapur, it was ascertained that the vehicle was registered as number HR26DV1271 in the name of Divakar Hospital Private Limited, so and so address Gurgaon. Immediately, the notice was sent to the registered owner. On 19th December 2021, a telephone call was received from Divakar Hospital stating that they have already received the insurance amount from Bajaj Allianz Insurance Company and further stated that they have informed the insurance company for recovery of the vehicle from the police station. The IO also received a call from Bajaj Allianz Company on 19th December 2022 to inform that the company has paid the insurance amount to the owner and the legal right to claim, and further stated that the company will come and make their claim. However, despite the above assurance and repeated reminders by the IO and by the concerned police station, the insurance company failed to turn up and make their claims. Officer in charge of Dimapur East PS, as a measure of abundant caution, issued one last and final notice dated 18th April 2022 to come and claim the vehicle on or before 30th April 2022. But despite the notice being duly served and notice period already expired, none had turned up to claim the vehicle. Meanwhile, the IO of the case had filed a final report being East PS FR number 4 of 2022 dated 4th February 2022. From the aforesaid, it is seen that despite the efforts of the IO of the case and the OC of the police station, none has turned up till date to claim the seized vehicle. The said vehicle is lying at the police station since the date of its seizure on 3rd of March 2021, and the same cannot be kept lying unclaimed indefinitely. In Sundar Bhai Ambalal Desai versus another versus state of Gujarat, so and so, it was observed by the Honorable Supreme Court as under. In case where the vehicle is not claimed by the accused owner of the insurance company or by the third person, then such vehicle may be ordered to be auctioned by the court. If the said vehicle is insured with the insurance company, then insurance company be informed by the court to take possession of the vehicle which is not claimed by the owner of a third person. Your Lordship, I'll take the liberty to read this line again because he has mentioned, he has relied upon this judgment and not followed this judgment. If the said vehicle is insured with the insurance company, then insurance company be informed by the court to take the possession of the vehicle which is not claimed by the owner or a third person. No notice was issued to insurance company ever.
no, in the above, we have seen
Yes.
notice was issued.
No notice was issued, never was it was received by
But
us.
they have mentioned here. You
No,
have
Your
just
Lordship,
read.
all that is mentioned, they have not placed any copy whatsoever on the record. There is nothing on judicial file and no notice is issued by the court of district and session judge ever.
No, it says that notice was issued, nobody came.
No, whatever the police may say, but it is the duty of the court to issue the notice to the insurance company. This is what the judgment says. By the court. No, the learned district and session judge totally relied upon the steps taken by the IO.
Just come back.
Yes, please.
Despite the notice being duly served and the notice period already expired,
Here is the notice, Your Lordship. There is
No
a
one had
copy of
turned.
the notice. Who received the notice from our side?
how, then what is the interest of the court? Without serving notice, how the court will?
This is why I have filed this writ petition, Your Lordship. These are the
Maybe
questions.
it may be on record. Maybe
I have
on
seen
record.
whole judicial file. I have placed the whole judicial file certified copy on the record.
Hmm.
And if Lordship will see, I will show from this record, from my petition, from the orders of the learned magistrate and CJM, what has happened. May kindly grant me some more time. May kindly, I will read further, Your Lordship.
Okay.
If insurance company fails to take possession of the vehicle, may be sold as per direction of the court.
Hmm.
The court would pass such order within a period of 6 months from the date of production of the said vehicle before the court. Accordingly, the seized vehicle, a Toyota Fortuner bearing registration number so and so, is hereby confiscated, and the same would be sold through auction. However, since the vehicle is lying in the PS for more than a year, a technical estimate and roadworthiness of the said vehicle be first assessed by the motor vehicle inspector from the Office of District Transport Officer, Dimapur. Now, Your Lordship,
So
this
where
is
is the informative? So it appears that from the order, it
Yes.
appears that they have followed the rules.
No, Your Lordship. May kindly
Hmm.
see page number,
Page number.
Your Lordship. Page number 44.
What is that?
Yes. This is the order of the learned judicial magistrate first class of Dimapur, where the application was filed for the Jimma petition of this vehicle. Now, Your Lordship will see
When this was?
this was filed. This is the order dated 23rd of March 2023.
No, this order was passed 15/7/2022.
Yes, please, I'll make my submission.
Session just passed order
Session judge passed this order.
22.
He summoned the
Yeah,
file. He
And you
summoned-
made an application after that.
Yes, because we were having no notice about this order or the any notice about the auction or the confiscation. That is why.
This order was passed almost a year back.
Yes, Your Lordship.
Oh, then,
Yes, if Your Lordship will see, kindly see.
yes.
This file was totally not traceable in the office of judicial magistrate or in the office of district and session judge. Kindly see.
Hmm.
So and so, this, Your Lordship.
Yes.
As such, it appears that the case record is not in the GR branch of the, and neither has been same been duly endorsed to this court. In the light of the above, present case is sent back to the court of CJM for necessary steps. May kindly see the next page, Your Lordship. This is the
No, it
order
was-
of the
it- It was not before the judicial magistrate first class.
yes.
Why you have filed there?
Because he was the court of judicial magistrate was the original court with the jurisdiction to file this application under section 457.
But the matter are being reported before the chief judicial magistrate only. Thereafter only it will be
This
endorsed to
was
judicial magistrate first
this was
class.
filed before the CJM. It was sent to the judicial magistrate first class for proper order by the CJM itself. This application was made before the court of CJM only, but the learned CJM delegated this
Oh,
file.
that can be done.
That can be
That
done,
can,
yes.
that can be.
Then the judicial magistrate first class sent it back to the CJM only. Since the file was not traceable. Now, kindly see the order passed by the CJM at page number 45. May I read for page number 45?
Yes.
Perusal of the record reveals that 23rd March 23, learned counsel for the petitioner moved an application under section 451, 457 of CRPC, praying for the release of vehicle bearing number so and so, which has been seized by the investigating agency in Dimapur East PS so and so, corresponding to GR 4114/21. Accordingly, upon receiving the application, the same had been registered as IA number so and so, and the matter had been endorsed to the learned JMFC for passing orders. However, on 24th March 23, an order has been received from the learned JMFC stating to the effect that the information IA could not be taken up as the CR is not traceable and the same is not found in the GR branch. Upon receiving the said order dated 24th March 23 passed by the learned JMFC, this honorable court has gone through the FR endorsement register of the court, and it has been found that on 11th July 22, on being asked from the office of the learned principal district and session judge, Dimapur, the FR case report had been handed over to Shri Jungshi. This being the case, the branch assistant is to take necessary steps for production of the FR to enable this court to take up the IA number so and so, issue extract copy of the order to concern of information. Now, Your Lordship,
Yes.
after that, page number 46. The judicial file was summoned, it was called by the CJM, and this order of release of the vehicle to the custody of petitioner was passed. Had there been any order or any notice was there on the file, then the learned CJM would not have passed this order. Kindly see the last para, page
Just
number
see,
47.
Just see, the council,
Yes, sir.
the session judge has already passed an order way back in July 2022.
Yes.
These all orders seems, you say, you deliberately filed this before the CJM and JMFC.
No,
After that,
No, not deliberately.
What-
We were not having any notice whatsoever, sir. And this order, which was passed by the district and session judge, was
you
without
said
any
you said that you
jurisdiction.
took photographs also. When did you take photographs?
It was taken in the month of March 2022.
Okay, thereafter, you know that the case was
Yes,
disposed of.
yes, after that, in July, it was filed before the CJM for passing necessary order with respect to the seizure of this vehicle.
No, just a minute, yeah.
If your lordship wants to know the timeline, I can confirm the timeline. But the substantial question here is, did the court of district and session judge had the power to summon this file from the office of
Just a
CJM?
minute, just a minute. Huh? Where is the sentence which says that in the meantime, the police has filed final report?
In
Hmm?
which order? Impugned order?
No, in the order where it was reflected that.
Lordship,
In the-
sorry for indulgence, Lordship.
Yeah.
Now, my learned friend has started the hearing. Now, LCR will be required, Lordship.
Yes, sir, that is what I'm saying. So
There's no LCR here.
the LCR, so he said that there are no record. LCR, just would like to confirm. Where is the order where
Okay, page 68.
68?
Yes, first second paragraph, last
Yes,
line.
yes, in the meanwhile, the IO of the case had filed a final report being so and so. That was also in the way back in the 2000, February.
Yes.
February.
Final report will never file before the
Session
session.
judge, yes.
It will be filed before the CJM only.
CJM.
So CJM, it was again in the knowledge of the CJM also.
It was in the knowledge of
Hmm,
the
yeah.
CJM, but it
So
was for the CJM to pass
Hmm.
necessary order
So
with respect
what you
to
are
that.
submitting is that no record has been found.
No record was found on the
The record would be
judicial
needed.
file. Yes,
We
and it
need
was
to
not,
proper-
it was not summoned through proper channel.
I have
It
no
was
idea.
not summoned, this file was not summoned through any judicial order whatsoever. There is a rule and procedure laid down through which a file can move from the establishment of
So
CJM to the establishment
You
of.
mean to
district
say that the police by filing this complaint or this application before the magistrate was, of course, should have been before the chief judicial magistrate, but then
Yes.
he. has
But he did
filed
not
it
pass
before-
any order. They should have waited. And as the appellate court, the powers of session judge should have been invoked. But his powers were invoked as the original court, which is not allowed in law. Kindly see section 457 of the CRPC. If your lordship will say, I will read the basic section 457.
CJM.
Yes, your lordship. Please, your lordship, I'll permit me. Section 457.
Yes,
of
that is
CRPC.
there, that is there.
Yes,
That is
Kindly-
there.
yes,
CRPC, that is there.
please, your lordship. Let's examine this section.
Section?
457 must be on page number 246.
Yes.
Section 457, procedure by police upon seizure of property. Lordship,
Yes.
whenever the seizure of property by any police officer is reported to a magistrate under the provision of this code, the such property is not produced before a criminal court during the inquiry or trial. The magistrate may make such order as he thinks fit respecting the disposal of such property or delivery of such property to the person entitled to the possession thereof, or if such a person cannot be ascertained respecting the custody and production of such property. If the person so entitled is known, the magistrate may order the property to be delivered to him on such condition as the magistrate thinks fit. And if such person is unknown, the magistrate may detain it and shall in such case issue a proclamation specifying the article which such property consists and requiring any person who may have a claim thereto to appear before him and establish his claim within 6 months from the date of such proclamation.
But that is there.
Even the magistrate has to wait for 6 months.
No,
Please,
so
Your Lordship,
here-
kindly
here-
see
here-
section 458 also. May I'll read section 458.
Yeah, because
If-
the police has straight away approached the.
Approach it is for the magistrate to pass the necessary orders. May kindly see section 458 sub para 2. And section 458 sub para 2, an appeal shall lie against any such order to the court to which appeals ordinary lie from the conviction by the magistrate, that is sessions. He could have heard it as an appellate court, as a revisional court, but not as an original court.
Yeah, that is true. And then it appears that it was not seized in connection with any criminal case.
Any criminal case.
That is
It was-
why.
It was found.
That is why the police probably has straight away went to the session court. So, are there also passed any order? Yes, it has.
Though they first approached
Today is listed for what?
district for admission.
Record was not called for while issuing.
No, not yet.
We need to call, we need to see the record.
May kindly call. No issue. You know, Your Lordship will see that there is nothing on record. That is why CJM had passed these orders. Had there been any
Let us.
record, any order on record, she would not have filed,
Yes, you have.
passed these
anything-
orders.
Lordship has second already seen the records, Lordship, unless the original LCR is called
Yes,
for.
yes, yes.
How the process was. Now they are saying that there is no record,
Hmm.
but he is placing everything in his petition.
Okay.
That's a misleading statement, Lordship. And the manner in which the vehicle has been auctioned, Lordship, the record will speak. Final notice was issued to them, they are well aware of it. They never came to claim.
Everything will be there on record. I don't have any objection to it. If they should, notice was issued, it should be there on record, where it will go.
Oh, hard, Mr.
Nitin Tittal. I'll give a slip.
Nitin.
Nitin Tittal.
Okay,
I'll give a slip, Your Lordship.
okay, this is item 5. Okay, Land Council for the petitioner. Also heard,
Correspondent number 3.
both are appearing. You are for?
Respondent number 3
Okay, Mr.
and Mosul.
and Mosul, Land Council for appearing on behalf of the respondent number 3, and Mr. Angami for respondent
Number 1.
respondent Angami first, huh? 1B first, okay? Stop, huh?
Respondent number 2 has been deleted because they have deleted the courts.
Yes,
Respondent number 2.
Lordship, previously I was engaged by number 2,
Yes.
that's the Sing Judge, Mapur.
okay,
Since by an order 2011-2023, the Ismam 2 has been deleted, so my name may be also deleted. Lordship.
okay, 6. Huh? Since the respondent number 2 has been deleted from, struck off from the array in the present writ petition. The name of Mr. Posego Forte, who represented respondent number 2, may also be deleted from the cause list.
Yes, Lordship,
Okay.
may be deleted. Lordship.
Stop. Huh? For proper appreciation of the case, the record in this case would be record of the They have to record from both
Should be, Lordship.
CJM as well as the,
Yes, GR case as well as the
okay,
supplementary case.
the record of both the, what is the, where is the impugn order? Where, impugn order is in page,
Impugned order is 15 July 2022,
no, page
page 67.
67. Okay. This was registered as,
Supplementary case number 1 of 2022.
both the case being supplementary. Supplementary case number 01/2022 arising from GR
414 of 2021.
See, this session judge also referred GR case. GR
Yes,
is
it
in
was
the
in the same
magistrate
GR.
only.
Yes, same, it should have been
GR
annexed
in-
with that.
GR in the magistrate only. So must have called the record from the magistrate also.
Yes. That's.
It was not called
So he
officially.
referred. So you are saying that
No,
not
no,
very-
He did say.
Your
the
your lordship will
GR
examine
record was-
the original
GR
record, then we'll see.
4/14/2021 corresponding to Dimapur East PS case number. Okay, PS case also 152/2021 under section 460. See, it was his, okay, 465, 471 IPC. And where is the latest, the order passed by the CJM you just referred?
CJM
CJM.
passed the
And,
order on
hmm,
page number 46.
see, this is same GR case.
Same GR case. But that order was not on the file. That is why she passed this order.
So on being called, it was referred, it was forwarded.
No, not, it was not forwarded. Kindly see kindly
Okay.
see on page number 43,
And
she has
also
mentioned.
the GR case number, GR number 414/2021 is PS case number
It was given
152
unofficially.
152/21 section 465, 471 IPC. Pending before the, earlier was pending before, as before the Lannis session court, principal district and session judge. And this one, number so and so, before the chief judicial magistrate, Dimapur. Stop accordingly. Let the above records be called for. List this matter after receipt of the record, said record.
Obliged. Obliged, madam. Obliged.
For orders, item number 22. Item 22. 22. Yes.
May I please, Lordship.
Yes.
My lord, today the matter is fixed to hear on delay, condition of delay.
Okay.
My lord, in this case, I have been appointed amicus curiae to defend the accused.
Okay.
Lordship, the delay I have explained from paragraph 3 of the IAMI.
Who are the respondents? Yeah.
My lord, response state.
State only.
And then the other one, the father of the alleged victim. In two occasions, steps have been taken.
You are representing the accused.
Accused.
Okay.
Through-
Who represent the,
As amicus curiae. Yes.
who represent the respondent number?
No one.
Two.
Notice
So
still.
this is what case is this, otherwise?
The POXO case, my lord.
Then the appearance of this respondent would be necessary. Their notice was issued to them.
In two occasions, we have taken step, but still notice return unserved all the time. Maybe
Then I think
Lordship, Lordship,
you're for state.
Lordship,
But then and I think then the respondent number 2 should also be represented by the legal aid counsel.
better because they will not receive the notice.
They will not receive, and probably
Mm.
even if receive also, they will not be able to.
Otherwise, My lord, as per the latest High Court notification, dated 20 March 2024, it is not necessary to implead the victim or the complainant
No, it is necessary.
in respect of certain sections. But
Okay.
as far as this
What section is this?
is,
Section involved is?
I'll just read out, my lord. Rule 1A, it shall not be obligatory for the appellants or petitioner to implead the informants in criminal case, complainants, victims, or the accused person, as the case may be, as respondents in appeal filed under section 378 of the Code of Criminal Procedure or under proviso to section 372 of the code, and also in the revision petition under section 397/401 or in the petition filed under section 482 of the Code of Criminal Procedure. Of course, here in our case, we have filed challenging the conviction order. Otherwise, in all the other cases, impleadment is not required at all now, as per the latest
Conviction in
code.
POCSO Act would be required.
Even under POCSO, if it is revision, it is not required.
This is revision what?
Yes, no, this is not revision, my lord.
No, this
Not
this is
revision.
appeal.
My-
It will be required.
Yes.
Yes, sir.
So at least, my lord, my humble prayer today is, today is fixed to hear the delay. So at least delay may be condoned after that. No problem.
Yes, sir.
This is pure, the delay is purely because of the delay of COVID time, COVID-19. Yes,
Delay of how many days?
1,455 days.
1,000.
450. I was also appointed very late by the Legal Service Authority.
This jail appeal.
Yes, jail appeal. The person is still in, since his arrest, he has never been released on bail also.
Convicted for how many?
10 years.
10 years. How
Yes.
long he has been inside?
He was arrested in 2017. Since then,
Okay.
so
Almost
he has served for almost 4 years now.
17. No,
Yes,
it will be
since 2017. This is 2024 now.
almost 7 years.
Yes, my lord. And the sentence maximum is 10 years only. So at least the delay may be come down, and then if anybody can represent for the alleged victim's father, complainant, at least that will do justice to both the parties. Otherwise, without.
Yes, Lana PP, what do you say?
Lordship, Lordship, I'm appearing on behalf of Zimo, Lordship.
Jimmo.
Lordship,
Yeah.
I pray that this matter may come up after 2 weeks, Lordship.
The special PP is not present.
Lordship is not present.
My lord, I have another fixes in district court, it's criminal case. So that's why I have even upgraded the first
Yes, sir.
hearing. So that if lordship pleases, at least it may be calmed down because I have explained everything para
The
from
PP
para.
is also not present. I thought if the PP is at least with the consent of PP,
Because
so
they
we
have
can fix
commit-
it one early date.
No more, no problem.
Okay.
Tomorrow election day, so after this only.
Okay.
My lord, in the cause list, if my name can be reflected as amicus curiae,
Okay.
because by the registry, that is not done,
Oh, not reflected.
not reflected.
This is item
Item 22, my lord.
22.
Yes, 22.
Okay. So it is only Mr. Angel, learned amicus curiae. For the appellant. Also heard Miss
S. Chang, Lordship. S. Chang.
appearing on behalf of Mr.
Vijimo,
Vizimo. He's Zimo is PP.
Lordship.
PP staff. No one appears on behalf of the respondent number.
State 1. One.
One. No, it's two. Okay, sorry, respondent number one.
Yes, my lord, state is one.
No, state is one. So the private respondent is
Two, my lord.
two.
Two.
Yes, yes. Okay. Service of the office note on various date reveals that notice
I'll come to case 2 days.
was issued upon the respondent number two. However, respondent number two, since
Right down.
since March 2023, however, the service report is still awaited. Due to which this the application for condonation of delay could not be taken up for hearing. Stop. The registry cell, sorry, the registrar, come Secretary, High Court Legal Services Authority, shall take steps, shall appoint a legal aid counsel to represent the respondent number two to informant.
Yes, madam.
Okay, stop. List this matter after 2 weeks. We'll say 2 weeks, no?
Madam.
Mm.
My lord,
Okay,
like I mentioned, at least my name may be letter amicus
Okay.
curiae.
okay. Since Ms. Khan, may, okay. The registry also shall reflect the name of Mr. Azo as Lara amicus curiae for the appellant. Okay.
Major.
In the cause list, huh? Okay. Yes.
For hearing item number 33.
May
Okay, yes. So since this is a POXO matter,
May I please, Lordship. My lord, this matter was more or less arguments over last time.
yes.
Yes. Lordship was in a question to me, make a query to me to find out what of us in POXO, whether the informant is necessary to be make necessary party, which I did not do here. Now I have checked, like I have said, now my lord will see a copy. Just now, which I have read out now. This is revision. So in the case of revision in criminal, to implement the informant is not necessary as per the order of High Court here. Lordship, I'll just see.
This is not the appeal.
This is not appeal, my lord. This is revision, criminal revision, my lord.
Criminal revision.
Yes, my lord. So therefore, in the case of criminal revision, for to implement the informant is not required, it's not necessary as part is not given High Court or on High Court here. My lord. We have final.
So there is a notification.
Yes, my lord. Jason,
Let us see.
This is the latest notification, my lord. We have
Notification.
Mary, my lord.
Yes.
Same.